Hello, I'm Peter Afrasiabi, partner with One LLP, and today's program is called Terrorem, California's 17200 Unfair Competition Laws. This program is for the California lawyer and the non-California lawyer. It's for the business litigator, and it's for the general practitioner, and it's for the transactional lawyer. It's for lawyers across the country, in other words, who want general credit and want to understand the reach and often terrifying scope of California's 17200 law as it engrafts onto behavior that one often thinks is not California directed, but which California courts may disagree with you on. So today we're going to look at these famed laws coming out of section 17200 of the California Business and Professions Code and how they reach both non-California businesses but also California businesses. We are only addressing the 17200 component, not the false advertising provisions under 17500 of the California Business and Professions Code. For 17500, stay tuned. That's another program for another day. We will look at the bases for liability in today's presentation and the reach of claims. And again, this really relates to both California and non-California attorneys in terms of how you counsel and prepare your clients as they send their business wares out into commerce throughout the country. We will look at the substantive standards, and those are the unfair standard, the unlawful standard, and the fraudulent standard. We'll look at the remedies, and fitting to the title of this program, we'll have several in terrorem slides as we work through some particular practice pointers in terms of the real scope and reach of these laws. So let's start with the history of 17200. Originally, 17200 from the Business and Profession Code was enacted in the early 1930s. By around the early 1990s, there were only 200 reported decisions that mentioned section 17200. If you think about that over 60 years, that's about 3 a year. It's almost none. Now, today, we have over 200 a year being issued from California courts. So what happened? Well, there were massive amendments in 1992 and thereafter that opened the way for more litigation under section 17200. Critically, until 1992, unlawful business practices under 17200 really required a genuine pattern and course and conduct of behavior, and not just a one-time event. But in 1992, the California legislature amended section 17200 to allow any individual act to count, irrespective of a pattern or course of dealing. And therefore, 17200 could be used by plaintiffs to reach even one-time acts that were not intentional, that were negligent, and were not the part, of a typical course and pattern of practice of unfair or unlawful dealing. That amendment spawned the massive litigation that's ensued for the last 30 years. So let's take a quick look at the overview of the statutory scheme. Section 17200 provides, as used in this chapter, unfair competition shall mean and include any unlawful, unfair, or fraudulent business act or practice, and any unfair, deceptive, untrue, or misleading advertising. Now, what this ultimately means is that section 17200 defines unfair competition to exist if there are 5 different kinds of wrongs that can occur. And we have them listed here for you. You have an unlawful business act or practice, an unfair business act or practice, a fraudulent business act or practice, an unfair, deceptive, untrue, misleading advertising, and then any other act that's prohibited by section 17500 to 17577.5. And those examples are specific statutes such as saying made in the USA when the product's not made in the USA. Now, we are not looking, as I said earlier, at section 17500, so that 5th prong is not at issue for this program. And the reality is that that 3rd and 4th prong of our 5 identified prongs here, they merge into the same substantive fraudulent test, so they're not really at issue. So really what we're looking at is unfair, unlawful, and fraudulent. Those are the 3 categories of the statutory scheme that we're concerned with in the 17200 program. This gets us to our first in terrorem. In terrorem number 1, the statute is in the disjunctive. What that means is that unlawful behavior may be actionable even if it's not unfair and even if it's not fraudulent. It also means that unfair behavior can be sued upon even if a claim for unlawful behavior may be barred. And we'll go to in terrorem number 2 since we're on this topic. 17200 is not simply about competition. This is a critical focus of the statute. And here you see a quote from a typical California Court of Appeal decision. Here it's Hewlett versus Squaw Valley Ski Corp. And the court says, the unfair competition statute is not confined to any competitive business practices, but it is also directed towards the public's right to protection from fraud, deceit, and unlawful conduct. Accordingly, 17200 is about threats to competition, but it's also about protecting consumers, and it's got a consumer protection angle. That, of course, is what's spawned in the last decades so much consumer class action-based litigation built around 17200. Let's now get to our substantive prongs. The first one is the unlawful prong. What does unlawful mean? Well, you can see here on the slide that the unlawful prong makes it a violation of an underlying law, a per se violation of 17200. So the question then is, what underlying laws can be borrowed to trigger a violation of 17200 by way of tripping over the unlawful prong? Well, federal statutes and regulations can be borrowed. This includes criminal statutes, trademark, environmental, labor, securities, and it also includes federal regulations such as FTC rules, NASD rules, government procurement regs. A whole range of federal laws can be the borrowed law for an unlawful claim. It also covers state statutes and state administrative regulations, such as in the antitrust, civil rights, consumer protection, employment, professional statute type space. Even local ordinances, such as zoning and building codes, can be predicate laws to be used to show a 17200 violation. Cases have even gone as far as allowing judge-made common law to be the borrowed law. There is an open question, however, about foreign state law, and that's both foreign to California as in other states in America, but also foreign as in foreign nations. And it's unclear actually as it stands today, and there's a potential split in the courts on this. And so there's two cases for you to compare. You have Schwartz versus Upper Deck, which is a Ninth Circuit decision applying California law. And there the Ninth Circuit allowed a 17200 claim that alleged the defendant's manufacture and sale in California of trading cards was unlawful because it violated New York, New Jersey gambling statutes. And so there it was allowed. So it's possible, of course, that breaking a foreign law can be used, at least in the Ninth Circuit applying 17200, as a precept for a 17200 claim in California. Now, on the other end of the spectrum, you have a California decision that confronted employment agreements that were used in California, but those agreements were entered in India, and they complied with Indian law. And the California court said that it was not unlawful under 17200. So it's also possible that complying with foreign law means one cannot be deemed unlawful under 17200. So those are two polar ends of the spectrum, and foreign laws still, it's a little open as to how it can be used. This leads us to in terrorem number 3, and as you saw, we alluded to some of the borrowed laws, including FTC laws. And the federal FTC Section 5 laws have no private right of action, and so businesses, by and large, only face the prospect of FTC action, if any is going to be brought, if the federal government gets around to suing them under Section 5. And those Section 5 of the FTC laws obviously are very broad, powerful laws where the government can come in and has extreme power to shut down businesses and secure really brutal monetary awards in terms of restitution and injunctive relief. But companies are only subject to them if the government brings the action. 17200, on the other hand, allows a plaintiff to borrow those FTC laws and make them actionable under the unlawful prong of Section 17200. That now gives terrifying scope to federal laws that otherwise don't have private rights of action, and this exists in California. Let's shift from the unlawful prong now to the unfair prong. What does unfair mean? Well, and here's the money quote perhaps, unfair can be a whole range of things. From the Bank of the West, California Supreme Court decision in 1992, the Supreme Court said, the legislature intended this sweeping language to include anything that can properly be called a business practice and that at the same time is forbidden by law. So, in competition-based cases, the word unfair means conduct that threatens an incipient violation of an antitrust law or violates the policy or spirit of one of those laws because its effects are comparable to or the same as a violation of the law, or otherwise significantly threatens or harms competition. On the other hand, in consumer cases, unfair can be following the rule, the FTC three-pronged standard, whether the practice, without necessarily having been previously deemed unlawful, offends quote-unquote public policy, as it has been established by statutes, common law, or otherwise. In other words, whether it's at least within the penumbra of some common law, statutory, or other established concept of unfairness. Or number two, whether it's immoral, unethical, oppressive, or unscrupulous. Obviously, those are very broad and elastic nouns. Whether it causes substantial injury to consumers or even competitors or other businessmen. So as you can see, unfair is extremely broad. The next question is, how do you prove unfairness on this slide? Well, for advertising practices that are being challenged, you look to the audience and you test it with experts. Here's a limit. If a practice has been declared expressly lawful, it cannot also be unfair. But if a law is silent as to lawfulness, and there's no express positive statement of lawfulness, then it can be deemed unfair. So there's this very delicate line between a not unlawful practice that can be unfair and an expressly lawful one that cannot be unfair. So when you're doing your research into California law and you think that something is lawful, you want to be very careful to isolate, has it been declared positively lawful, or is it silent? It just hasn't been declared unlawful yet. The latter can trigger unfair liability, the former cannot. So let's take a look at some examples of some cases from the case law where holdings have been found to find business practices and behavior unfair. The first case, and you have the case sites here on the slide so you can go read the cases in detail because I won't go through them in excruciating detail. But the first case just deals with, it's a business-to-business competitor case. The defendant was telling customers that, well, that plaintiff's patents, they may be invalid. Plaintiff didn't like the fact that its patents were being declared invalid or tossed around as invalid by a competitor, so they sued saying that's an unfair practice, and that was held to potentially be an unfair practice. You have a bank practice of dual tracking where they were agreeing to loan modifications while also seeking foreclosure. That was deemed unfair. You had a case, actually a litigation against shorthand reporters of deposition transcripts where they were charging higher rates than the normal copies for depo transcripts, where the party receiving the original was also given an undisclosed discount as a result of an exclusive volume contract between them and the insurance companies. That was deemed potentially unfair. Even asserting a contractual right that one does not have can be deemed an unfair practice. And so you can see through those examples, it triggers a whole range of conduct and is potentially very, very broad. Let's now look at some examples of cases where business practices have been deemed not unfair. And so in the not unfair column, we have one example. This is from the Northern District of California, sitting in diversity, applying 17-200, where a court held it was not unfair for a chocolate manufacturer to fail to disclose that there may have been instances of child and slave labor way down the supply chain. So in other words, the Mars company, as its wrappers or ingredients or whatever are being made by its vendors and whatnot down the supply chain, maybe they dropped into some country where there was child labor or other types of improper labor practices, and that was not deemed an unfair business practice for the Mars company then to fail to disclose that when they're selling their candies here in America. Another example is that it's not an unfair practice for a manufacturer to refuse to deal with a distributor since, given the antitrust laws, the defendant has that right to deal or refuse to deal with whoever it likes. And so there you have an example of positive statement of the right to deal or refuse to deal. Finally, another example is Rubenstein versus the Gap, and there the court held that it was not an unfair business practice for the Gap to sell its branded clothing at a factory outlet, even if that clothing at the factory outlet had never been previously on sale at a traditional Gap store. And so it could just go direct to the factory outlet. That's not unfair. This brings us to our fourth in terrorem slide, in terrorem number 4. And as you can see here on the slide, the point for this practice pointer is that it's not just commercial behavior that is subject to litigation and lawsuit. And in fact, it can touch a whole range of behavior. So you have Films of Distinction versus Allegro Film Productions, and you have this Isuzu Motors Limited versus Consumers Union of the United States cases. Both are cited there for you from 12 F sub 2nd, and these are Central District cases. And each of them have held that there's simply no requirement that the activity or conduct that someone seeks to enjoin under 17-200 has to be commercial conduct. The Isuzu case is a very good one to look at, because there, Isuzu was unhappy that there was this nonprofit consumers organization out there making what Isuzu felt were defamatory statements and comments about their Isuzu automobiles. Isuzu was unhappy. They didn't like the fact that this nonprofit consumer organization is, damaging their ability to sell their cars. At least they felt that way. And so they felt this is an unfair business practice, and they sued under 17-200. And the nonprofit consumer organization, putting aside sort of free speech and SLAPP statute and all that stuff that you're familiar with as California lawyers at least, the California federal court said that the fact that you're involved in speech that was completely non-commercial, it was just consumer reporting advocacy type speech, didn't put you outside the reach of a 17-200 claim by Isuzu. And so the organization had hoped to find an escape hatch on the theory that, look, we're just engaging in advocacy type fairness speech, alerting consumers as to the pros and cons and pitfalls and dangers and positives of products. How can we be sued under 17-200 because you don't like what we have to say? And 17-200 does have that reach. Now, it's as far potentially as reaching religious speech. And so here you have Pines versus Thompson from 1984. It's reported at 160, Calap 3rd 370. And if you go to page 386, that's where you get to the core holding of the case. And there the court held that a nonprofit religious group's publication of a Christian Yellow Pages was held to be a business within the scope of 17-200, and so was fair game for litigation under the 17-200 unfair or unlawful prongs. So the point here of Terrorem 4 is that it's really not just commercial behavior. It can be speech advocacy type behavior that can run afoul of the laws, trip over those laws, and run your client into litigation problems in California. And so I think this is a particular practice pointer and useful tip for transactional lawyers, both in California, but especially outside California, who may be advising their clients and who are utilizing general common law precepts from the state that they're in, and looking at some of the major states perhaps to think about how those comments of their clients may disseminate, especially through the internet, which has nationwide reach. To be aware, you want to think carefully through the potential reach of 17-200 to even those speech-related activities that your client may engage in, that they send out through Yellow Pages, or in the modern era through .com website addresses that provide access to folks all over the country. And then especially if they're generating ad revenue on those websites where the ads may be localized to California, they really could be subjected to personal jurisdiction in California under some of the case law. You want to think carefully through those issues to make sure your clients either alter what they're doing or recognize the scope of liability, and of course think about insurance that you may have that could protect for injuries and claims that could be brought of advertising injury or such claims under insurance policies. Let's shift now to the third prong. We've covered unfair, we've covered unlawful, and now we're going to look at fraudulent behavior within the scope of 17-200. Under 17-200, a business practice is fraudulent if, quote, members of the public are likely to be deceived. That's it. And so you can see that's frankly a very broad and potentially malleable statement. And that comes from the California Supreme Court. It's the Committee on Children's Television versus General Foods Corp. at 35 Cal 3rd 197, and the quote comes from page 211. And what does it mean if people are likely to be deceived? What does that mean? What does likely mean? And the case law means that it probably means probably. It's actually not been definitively decided, but the safest bet interpreting all the case law is that if members of the public are likely, as in probably going to be deceived by the statement or the conduct, then something can be deemed fraudulent. Now here's what's really important, and this is where both litigators and out-of-state lawyers often get hung up when they're thinking through the potential scope of liability under the fraudulent prong of 17-200. The fraudulent prong of 17-200 does not engraft perfectly onto common law fraud. Common law fraud is a different tort, and it has very, very specific requirements that do not apply for a quote-unquote fraudulent behavior. So, common law fraud has scienter standards, the level of intent that you have to misrepresent and deceive someone. It has to have detrimental reliance, the inducement standards. All of those elements of fraud are not required to prove something is a fraudulent practice. In fact, they can be absent and the behavior can still be deemed fraudulent. So the reality here is that perfectly lawful contract terms that would not be deemed common law fraudulent under a typical tort fraud claim can be repackaged by a plaintiff under 17-200 on a claim or theory that this lawful contract otherwise presents terms in a manner that's sufficiently deceptive that the public's likely simply to be confused or deceived as to the meaning of the contract. So let's look at a very, very good case at this, and that is an example of lawful conduct, but it's still deceptive and actionable. The case here is Chapman versus Skype, and it's 220 Calap 4th, page 217, and it's from 2013, and it's a very standard case. There's nothing remarkable in terms of it being an outlier. And here you had a situation as follows. You had a customer who signed up for this voice over internet protocol services to get unlimited calling from Skype. And Skype's advertised program was that you pay a fixed monthly fee and there's unlimited advertising. Now, it said unlimited US and Canada advertising, but there was a little footnote next to unlimited. And the footnote then said that effectively unlimited means not unlimited, and it purported to delimit the unlimited nature of it. And so it simply said, well, you don't get all the calls anywhere in the world, it's banded by some other limits. And it was presented, it was a footnote, but it was presented and explained. And so under traditional contract law principles, the plaintiff wouldn't have a claim. The court looked at it and said, look, it says unlimited calls, but it's got a footnote. The footnote says here are the limitations, so it's not perfectly unlimited. So you can't really proceed on a traditional contract theory. But the court nonetheless said there was a perfectly viable 17-200 theory, because if you're going to advertise something as being unlimited and you want to drop a footnote that then refers someone to a policy that you then click on in the hyperlink that goes to another website that then says unlimited doesn't mean unlimited, you want to do that, you have now potentially run afoul of 17-200. And the court said that that could certainly potentially be misleading and confusing, and therefore actionable as fraudulent and as deceptive to it's potentially probably deceptive to not just a plaintiff, but a class of plaintiffs who see unlimited and believe that unlimited means unlimited, obviously. And so this is an example of where conduct that could be wrapped up as being lawful under a contract or not violative necessarily of contract principles can still be deemed deceptive and actionable. And so I think the practice pointer that's particularly important for transactional lawyers is, as you're drafting internet terms of use, of conditions for websites, or you're working with your clients on developing their advertising, and the clients obviously are looking to come up with the most compelling advertising possible to push the most amount of product or services to make them the money and the margins they want to make, they're incented to push the boundaries. And you may look at something and say, okay, fine, we've dropped a footnote, we explain it, it's right there at the bottom of the website, we're okay, no one can be really misled, they can't say they didn't understand when they clicked I agree. The problem is under 17-200, they may not understand, and it may still be actionable. And so you may think you're dotting your I's and crossing your T's, but the safest bet is, if you're involved in any internet business that's touching people in California, dot your I's and cross your T's under the contract, the state contract law that governs your contract, but also go research California 17-200 law to make sure you're safe. This brings us to in Terrorem number 5. The point here is that 17200, it's a strict liability regime. The statute imposes strict liability. It is not necessary to show that the defendant intended to injure anyone. That is a really, really broad statement. Strict liability is obviously a very difficult legal regime to be stuck within. Now, the exception to this, of course, is if the borrowed law for purposes of an unlawful claim under the unfair competition provisions of 17200, if that borrowed law has an intent requirement, then in order to violate the borrowed law, you would still need to show that level of intent. But if it doesn't, then it's just strict liability and you're off and running as a plaintiff. This brings us to in terrorem number 6. A business practice is not immune from attack under 17200 simply because it's become customary or habitual, either for the particular defendant or even for the broader industry to which that defendant is a part. This is a really critical point because this often conflicts with, traditional common law contract type principles about that may engraft onto understanding the meaning of terms of a contract, of what's understood in the custom or the industry of how things are done. And here you have, again, a bit of a collision between contract principles and 17200. And there's 2 cases that are worth looking at. I'm going to talk to you a little bit about the first one, the Cappuccio case, but really you should go read both of them if this is within the wheelhouse of what you're dealing with for clients. We have People versus Cappuccio at 204 Calap 3rd 750, and this is from the California Court of Appeal. And we have People versus Casablanca Convalescent Homes Incorporated at 159 Calap 3rd, page 509. I want to talk to you briefly about Cappuccio because it's a really fascinating case. Cappuccio involved a public attorney general, 17200 action. And so this was a case under 17200 that was actually brought by the state attorney general of California, brought by the people of California, to enjoin what were believed to be unlawful practices by some folks in the fishing industry. And so here, what was going on is as follows. Commercial fishermen go out and would, go do their fishing out and off in the ocean, and they would bring back squid, and the squid would then be delivered from the commercial fishermen's hulls of their boats up a conveyor belt into, buckets that, and big containers that would weigh the fish. And then the fish would be bought by the purchaser, who was then going to ultimately resell the fish. And there's strict fish and game laws and other statutes that require meticulous and careful weighing of the squid to make sure that it's weighed properly, that the appropriate amount of squid is paid for, and there aren't games being played in essence with the weighing of fish to get away with ripping off commercial fishermen essentially. But here's what happened in the industry. The industry recognized that as the squid was offloaded from the hulls of the boat, there was a whole bunch of other stuff that went with the squid up the conveyor belts, junk and trash even at times from the hulls, but also sort of junk fish, not even squid, and just junk fish that couldn't even be sold. And so the custom and the industry practice was to discount the weight for kind of the understood overage that was going on in terms of the stuff that was just in there that wasn't really squid. And so, if it weighed 100 pounds, maybe it was, and I'm just making up numbers, they would pay the commercial fishermen for 98 pounds instead of the 100 pounds, 2 pounds being the understood junk. Well, state attorney general didn't like that. They sued, and in the trial, the defendant said, well, I want to put on evidence of the industry custom to explain this difference between the recorded weight and the actual weight that's being paid for, and why we do these adjustments for scrap and junk fish that was mixed in with the squid. And this is part of the industry. It's us. We have 20, 30 witnesses, between us and other companies who can explain all this as being how the industry works and why it works. And the court refused, on a motion in limine, refused to even allow that testimony to be offered at trial, holding that it's simply irrelevant to whether something is violative of 17200. That goes up to the Court of Appeal, and the Court of Appeal affirmed, and here's the critical statement from the Court of Appeal. It said, quote, fairness based upon an industry-wide custom is not a defense in this case. And that is a very general proposition of law. So if you want to say something's fair because of an industry-wide custom, you may run headlong into not being able to get away with it. It just doesn't matter, in other words, that a business practice may have taken root and been understood to exist in a certain way in a certain industry, even for an extended period of time. Here, the state attorney general was able to come in and say, doesn't matter, it's still unfair. So that gets us through the three major prongs of 17-200: unfair, unlawful, fraudulent. Now, before we turn to our discussion and section on remedies, specifically injunctive relief, restitution, and the availability, potentially, of attorney's fees, we're going to pause and do a little section called Staying on the Cutting Edge. And the Staying on the Cutting Edge section is really designed and devoted to focusing on some of the most recent case developments in the California case law from the California Supreme Court on down. And these are some of the key recent 17-200 cases across a variety of different industries and business areas that make sense for you as litigators, but also especially as general practitioners or transactional attorneys, whether in California or outside California, who may be counseling and advising clients on how to structure leases and transactions and other kinds of real estate documents that may touch Californians. If that's the world you inhabit, then these cases will be particularly interesting to you. The first case is from the California Supreme Court. It's a 2018 decision called De La Torre versus Cash Call. It's reported at 5 Cal 5th 966. And this case was a class action against a California lender, Cash Call, a famous national lender that's well known, but it's principally based in California. And this class action alleged that Cash Call's business of making unsecured personal loans to consumers at high interest rates violated a variety of state laws, including the 17-200 laws. And what was going on is as follows. The class action was defined to include people who borrowed amounts above $2,500 at interest rates of 90% or higher. And that was a significant part of the definition of the class statute because there is state law that caps the interest rates on consumer loans under $2,500. And so this was focused on people who borrow more than $2,500 and hence pay higher rates than the caps on the sub $2,500 loans. And so what the court did was define the class as that, and the rates were up to 90% for those loans. And the trial court ultimately held in this battle that when the California legislature enacted this state law setting caps on interest rates of up to $2,500, that impliedly created the situation that it would not be unconscionable then to have different interest rates on loans greater than $2,500. In other words, by capping them at under $2,500, any loan above $2,500, it was an open territory. And that's what the trial court ultimately held in the case. Now, this case went on appeal to the California Court of Appeal, and then it wound its way up to the Supreme Court eventually. And fundamentally, what the California Supreme Court held was that that interpretation of the law, while positive statutory law for purposes of loans under $2,500, didn't create a safe harbor under 17-200. And so the court noted that while this state law, it was section 22303 in a California state finance statute, set maximum interest rates on loans less than $2,500, the question of whether a higher rate above $2,500 is unconscionable was an open question. And here the court said it could be. And so the court held, and here you can see the quote at page 980 of the opinion, that plaintiffs are neither bringing a cause of action under the financing law nor seeking remedies under it. Instead, plaintiffs advance an unfair competition claim under the unfair competition laws. The claim is premised on unlawful business conduct, which 17-200 prescribes. And so therefore, the court said that the fact that there may be finance laws that lack a private right of action to declare loans unconscionable doesn't create a safe harbor. The fact that those finance laws set caps does not create a safe harbor if you exceed the caps and you're outside the scope of the law. And so what the court said, and this is a very important quote, and it goes back to some of the practice pointers we've already spoken about. The court said, there is a difference between not making an activity unlawful and making that activity lawful. And that's the sort of money point here that's critical for you to take from this. The other important point to note here is that this California Supreme Court decision, it was unanimous. And so this is really critical to keep in your mind that state laws that define unlawful behavior and therefore imply that things outside the unlawful zone are instead lawful, well, that doesn't necessarily ring true when you push claims through the 17-200 prism. And so I think especially for transactional lawyers who may be used to looking at statutes and they see that there's a statute that puts a cap on a loan of up to $2,500, and so it's a very logical and plausible assumption to therefore conclude that, oh, if the loan's above $2,500, there's no cap on interest rates, we're free and clear. And that's just not true given 17-200, which enables courts to prescribe as being unfair something that hasn't been squarely ruled on by the legislature or declared by the legislature. So this is a very, very important case to keep in mind when you're doing your research and you're drafting your agreements for your clients. The next case we're going to talk about is called Taniguchi versus Restoration Homes. This case comes from the California Court of Appeal. It was actually published only late April 2019. So on the slide there, you have the Westlaw citation, 2019 Westlaw 1923068, but you can find it obviously in Lexis or on other services given the name. What this case was about really is as follows. You had a situation where people who have been found in default under loans are then confronted with the ability to enter a modification. And what sort of happened is as follows, and this is sort of the issue that's teed up by the case, where all or part of the principal secured by a mortgage or deed of trust ultimately becomes due because of a borrower's default in paying installments on that principal. There's a California Civil Code section, it's 2924C, and you see it quoted there, but it allows the borrower to pay the amount in default plus some particular fees and expenses and whatnot, and thereby cure the default, reinstate the mortgage, and absolutely avoid foreclosure. Now, in this case, what happened was that you had some borrowers who missed some monthly payments on a mortgage loan that had been modified after an already earlier default. And the modification itself, after the original default, deferred certain amounts due on the original loan, and that included some principal, and provided that any default would allow the lender to void the modification and ultimately enforce the original loan terms. So the question before the California Court of Appeal ultimately was, in order for these borrowers to cure the default and reinstate that loan under Section 2924C, did the borrowers have to pay the amount of the earlier default on the original loan, the underlying default, which had been deferred under the modification, or did they have to pay that plus the missed modified payments that caused the actual default on the modified loan? In that case, the trial court ruled, yep, they have to pay both. This went up on appeal, and this was put to the court through the prism of 17-200. It wasn't just a claim under 2924C. It also was a claim seeking injunctive relief under 17-200 to prescribe this practice in what was effectively a class action here. And so the trial court, as I indicated, said, yes, you have to make all payments in order to reinstate, but the Court of Appeals actually turned around and said no. And the key point here is that the quote that you see in the middle of this slide, it says, when principal comes due as a result of a default, Section 2924C allows a borrower to cure that precipitating default and reinstate his or her loan by paying the amount of the default, plus fees and expenses. Here the default is the failure to make payments on the modified loan. Accordingly, 2924C gives the Taniguchis the opportunity to cure their precipitating default, that is, the missed modified payments, by making up those missed modified payments and paying any late charges and fees with that. And that could avoid the consequences of the default on the defaulted loan. This is a really critical case of first impression in California because I think, at least from my general research and my understanding from talking to people in the industry, it's actually a not uncommon practice in terms of loan modifications that sit on top of earlier defaults to have contractual terms like that. But what you can see here under 17-200 is that those contractual terms are not going to stand. And so what happened here within the realm of 17-200 is that the 17-200 claim that had been dismissed on the theory that, look, the contract says this and we exercised our contract rights in good faith and so we should be immunized, that was rejected as a defense. And so the 17-200 claim then was exhumed. The final case I'm going to talk to you about is another case that's currently pending before the California Supreme Court, case of first impression, and it's one involving the right to a jury trial. So, this is the case of Nationwide Biweekly Administration versus the Superior Court. And the key point is that historically, 17-200 does not provide a jury trial right because the remedies are equitable. And we'll be talking about remedies on the next couple of slides and throughout the end of the program. And so what's important is that California cases have sort of made clear that the state constitutional right to a jury trial is the right as it existed in common law. And as the California Court of Appeal traced the history of the right to a jury trial, it concluded that when you talk about liability questions where a public prosecutor is bringing a 17-200 action and seeking penalties on some underlying laws within the guise of 17-200, well, at common law, there was a jury trial right to liability questions when you're being subjected to penalties by a prosecutor. And so when you have governmental-based 17-200 actions seeking these civil penalties, those are legal, not equitable, and thus there is a jury trial right to it. This was a massive decision in the California Court of Appeal because it's really the first time that a court has concluded that in the context of a 17-200 action, you'd actually have a jury trial right. Now, the California Supreme Court granted review. It's been briefed. It's pending before the Supreme Court. You can see the case site there if you want to go look at the briefs and pull them from the docket. But it's going to be a very important case because it will decide squarely whether there's a jury trial right that engrafts into 17-200 in public prosecutor 17-200 actions. But necessarily, by making a ruling about that, it will cast a shadow on private 17-200 litigation actions. And so there may well potentially be an opening now for the right to a jury trial for the plaintiff or the defendant in a certain set of 17-200 cases. And now we're going to talk a little bit about remedies. And within the realm of remedies, what we're going to talk about is the sort of general cleansing power remedy that 17-200 and the 17-200 statutes provide. And specifically the injunctive relief component of a court's equitable remedial powers, but also the restitution component of that, which affords transfers of money between parties, obviously. The general principle here is that courts understand that 17-200 statute allows this very broad cleansing remedy. And here's a quote from Fletcher versus Security Pacific National Bank, and that's a California Supreme Court decision from 1979. The general equitable principles underlying Section 17-535 and presumably also Section 17-203, as well as its express language, arm the trial court with the cleansing power to order restitution to effect complete justice. If you just stop for a second and pause on those words are incredibly broad in terms of the discretion that's granted and vested in a trial court to solve the riddle that's put before it. And if you stop and think about the sheer breadth of unfair, unlawful, and fraudulent in terms of how far substantively those standards reach, you can then understand why courts also have an equally broad reach when it comes to fashioning injunctive relief. The types of fact patterns that may be unfair or unlawful stretch and band across all sorts of legal regimes, and that can require all sorts of remedial regimes to fix the unlawful or unfair or fraudulent business practice that stands before a court. Now here, before we dive headlong into the twin remedies of injunctions and restitution, let's just take a quick guidepost overview of them before we go deeper. With respect to injunctions, again, the legislature intended to permit courts to enjoin ongoing wrongful business conduct in whatever context such activity might occur. Very, very broad. With respect to restitution, here's the critical overarching point to keep in mind, and this is sort of gives people some refuge and safety in terms of the fear of the reach of 17-200. Restitution is not mandatory, but it is available. And restitution is not the same as damages. Damages, in fact, are not available under Section 17-203. And that again comes from Bank of the West versus the Supreme Court, a 1992 decision reported at 2 Cal 4th 1254. The also big overarching point to keep in mind is that the statute itself does not provide for attorney's fees, but that does not mean that attorney's fees are per se precluded. We'll talk about that in a little while. But those are the guideposts. Let's now get into it on injunctions. With respect to injunctive relief, the legislature intended, as it used 17-200, to permit courts to enjoin any ongoing wrongful business conduct in whatever context such activity might occur. Equitable relief, such as injunctions, are not limited to business competitors, and courts can protect the public's right to be protected from fraud and deceit and may enter injunctive relief on that basis alone. As we shift to restitution, let's talk a little bit about the scope and the limits of restitution. The restitution provisions come from Section 17-203 of the California Business Profession Code, and it provides that the courts, quote, make such orders or judgments as may be necessary to prevent the use or employment by any person of any practice which constitutes unfair competition, or as may be necessary to restore to any person in interest any money or property, real or personal, which may have been acquired by means of such unfair competition. Now that broad power from Section 17-203 is subject to Supreme Court imposed limits. And the first one comes from the case of Cortez, 23 Cal 4th at 172. And this is a Supreme Court decision from California, and this is one of the earlier ones dealing with scopes and limits on restitution. And here the court held that restitution must be money or property that's unlawfully obtained or unfairly obtained, and that was in fact received and taken from someone. That is, in other words, if there's no showing of a defendant's actual receipt of anything, of any monies, for example, or property, there's nothing to disgorge within this restitution remedy. There must have been something entering the defendant's pocket that can then be restored. Now, this is not mandatory, and there's another limitation on this that we'll talk about in a few minutes from the Korea Supply case, but it's not mandatory even if a violation is shown. And here's a good example of a case where you have a violation of the 17-200 laws, but where the court refused to issue a restitutionary remedy. And so here you have the case of Olson versus Cohen from 2003 at 106 Cal 4th, page 1209. And this case involves the following. You've got a defendant law firm operating in California, taking on clients, doing the business that California law firms do day in, day out, and it never actually registered with the California State Bar. That, of course, is a no-no. It violates a variety of different state and bar rules. So the plaintiff learned about that, and based on that, sued on behalf of a putative class of, all the former clients of the law firm who had hired and paid the law firm, fees or contingency fees for litigation. And the plaintiffs contended in their class action lawsuit that there was this unauthorized practice of law in California. The law firm engaged in unlawful, unfair business practices. There's liability, and therefore they should be ordered to disgorge through this restitutionary remedy, this broad remedy of Section 17-203. They should be ordered to disgorge all the attorney's fees that the law firm had collected over the prior, 4.5+ years. The defendant files a demur, motion to dismiss, as we call it in federal court. In California practice, it's demur, of course, for those of you not from California. And the trial court sustained the demur, and the Court of Appeals affirmed. And citing the Cortez case, the court held, the decision to incorporate as a professional corporation is typically made to obtain tax advantages. It's not done for the protection of clients. And so therefore, the court concluded, to require disgorgement of fees because of a failure to register the corporation would be disproportionate to the wrong. So there you see a very, very good example of this flexible, broad remedial power for a court to target the remedy to the wrong. And here, there was liability and there was a wrong shown, but the underlying rationale and purpose of the wrong was one that didn't really engraft onto the plaintiffs and their securing of legal services. And so they were not entitled to receive as a remedy, as broad as a remedy is, all of their money back simply because of a law firm's technical failure to register with authorities, which was really serving taxing and other types of purposes, not client protection purposes. In other words, if the clients felt they had been victimized by malpractice or improper legal representation and they wanted their money back, they should have gone to those remedial claims that could have justified a remedy that would put that money back in their pockets. And they couldn't circumvent that through 17-200. And even though they could show liability, get the money back on the damages side. So this may be the flip side of an in terrorem for you. It makes you wipe the sweat off your brow and know that things are not necessarily that bad in California from a liability perspective. As we continue on to the next slide, looking at restitution and its scope and limits, one important point is that there's no need to show reliance or actual damage to get restitution. This is a really important point because the deterrent purpose behind Section 17203's restitution provisions is so important that the legislature has effectively authorized courts to order restitution without individualized proof of deception, reliance, and injury if necessary to prevent the use of employment of an unfair practice. Now, this is the next key limit, and that is that if there's going to be an actual return of money, it has to be money that's actually been taken from the pocket of the defendant or taken from the pocket of the plaintiff into the pocket of the defendant, because this is not a damages remedy, it's a takings type remedy of restitution. And so you can only return to the person those measurable amounts which were wrongfully taken by means of an unfair business practice. And so that laser-targeted requirement of a taking, for lack of a better word, it comes from myriad case law, including this Day case here you have cited. This brings us to Korea Supply, one of the seminal cases from the California Supreme Court. And here you have the plaintiff is effectively an arms broker. It's retained to promote its principal's bid to sell a missile defense system to the Republic of Korea. And instead, the contract was awarded to the defendant, Lockheed Martin's predecessor entity, but effectively Lockheed Martin. And so the plaintiff sues, alleging that the contract was unfairly won because of bribes and other illicit, offerings given to Korean officials, and they stole it from, the plaintiff who was going to get the contract because of these unfair business practices, bribery in effect. And plaintiff then said, I've shown liability for 17200. You violated, bribery laws, Foreign Corrupt Practices Act, other types of laws. There's liability, and so I want restitution. And the restitution I want is all the money that you, Lockheed Martin, made on your contract selling, missile defense systems and weapons and arms and whatnot to Korea. We want all that money back through the guise of a disgorgement remedy, through restitution. Should have been our money. You got it. Should have been ours. It's not fair. The Supreme Court said no. The Supreme Court said that money or property has, for purposes of restitution under Section 17203, has to be money or property that the defendants, Lockheed Martin, took directly from the plaintiff, or from which the plaintiff has a vested interest. And so a contractual expectancy where you never had the contract and so you never had the money isn't the type of thing that can subject a defendant to a restitution award. And so this is where there's a great line then in the law in terms of making 17200 as powerful it is on the liability front, not as powerful on the remedial front when it comes to money, because what would traditionally be a damages remedy cannot be rewritten as a restitution remedy. Let's take a walk through really briefly some case examples looking at this. And so you have Schuster versus Supreme Court. Here the court held that nothing in Korea Supply precludes an indirect purchaser from recovering restitution under the unfair competition laws against a remote manufacturer. Similarly, in Lozano versus AT&T Wireless Services, you have the case mentioned and briefed earlier a little bit, where consumers had this free vested interest, in essence, under their agreement in anytime minutes. And if those anytime minutes were lost as a result of an unfair business practice, and there the business practice was out-of-cycle billing and other types of sort of non-cycle billing practices that cause people to lose their free anytime minutes, if those were taken by unfair practices, then those free anytime minutes were something that the plaintiffs had a vested interest in under their contract, and so those free anytime minutes could be returned to them under Korea Supply because it was actually taken from them under their own contract with AT&T. Here we have the Central District of California applying 17200 law in Dalian versus DeVry University, and this is one of the higher ed professional school cases at 461 Federal Sup 2nd at 1121, pages 1156. Here you have a student who's at this for-profit higher education institution, DeVry. Plaintiff sues for restitution over allegedly false representations that the credits that the plaintiff student was earning at DeVry could be transferred to other institutions. And so basically the claim is that DeVry told people, hey, come here, pay us a bunch of money, you can get all these units, and these units are freely transferable to ABCD universities if you want to transfer. And it turns out they weren't as freely transferable. Some were transferable, but some were not. Some, you had partial transfers, some not at all. And so, in effect, the plaintiff said the value of the product and service you advertised wasn't good enough, and so I need restitution of the money I paid you to get those units back. And that was a viable use of restitution, to have the monies that were taken by DeVry from the plaintiff's pockets returned to the plaintiff for the units that were not freely transferable. Because of course that was a liability litmus test for that claim. Then we have National Rural Telecommunications Company versus DirecTV. And this again is coming from the Central District of California, the trial court at 319 F sub 2nd 1059. And here's an important point really where the court addresses the fact that restitution under section 1703 absolutely does demand that the plaintiff have a vested interest, in that money or property that's being restored to the plaintiff. It can't be contingent, it can't be conditional on something. It must simply be an absolute, unequivocal, unconditional, vested ownership right in that property, such as the free unit, the freely transferable units in the prior case. This brings us to attorney's fees. Attorney's fees is a very complicated area of section 17200 law, and that's because the law is as follows. Just because you may borrow a legal statute or legal regime that provides remedially for attorney's fees, and you may borrow that regime for liability purposes for the unlawful or unfair prong, that doesn't mean that when you sue under the unfair competition laws and you show liability based on that borrowed law, it doesn't mean that the courts will also borrow that law's remedial laws. In other words, that law's attorney's fees provisions that may be in the statute. So for example, if you take your traditional copyright case where there's a statute that provides for attorney's fees to the prevailing party, if there was some unlawful business practice claim brought that borrowed federal copyright law as the borrowed law for the unlawful prong, upon showing that you've now proven an unlawful violation of 17200, you are not allowed to also borrow federal copyright law's fee provisions in order to get attorney's fees. Now, there is an exception to that, and that is the private attorney general doctrine. And this comes up under California Code of Civil Procedure, section 1021.5, which is a general attorney fee provision for private attorney general actions. And this engrafts onto and enmeshes with section 17200 actions. And it works as follows. Attorney's fees can be recovered under a private attorney general action or under the private attorney general doctrine where, number one, the action has resulted in the enforcement of an important right affecting the public interest. Number two, a significant benefit has been conferred on the general public or on a large class of persons, so it doesn't have to be the entire public. Number three, the necessity and financial burden of private enforcement are such as to make the award appropriate. And number four, the fees should not, in the interest of justice, be paid out of the recovery, if any. So there you can see this sort of broad private attorney general action that's aimed and designed to allow the award of attorney's fees to plaintiffs and plaintiffs' lawyers, obviously, where they bring cases that are otherwise unlikely to be brought because the cost is prohibitive, and where they vindicate important public social rights as opposed to purely personal private rights or benefits. So on the next slide, you can see a case that's sort of taken this apart and has drawn the line in terms of where this is, and that is that Section 1021.5 is really intended as a bounty for pursuing public interest litigation, and it's not designed to be a reward for litigants motivated by their own private pecuniary financial interests who may coincidentally happen to serve the public in some sort of generalized sense as they frame it on the back end. It really is designed for bona fide public interest type litigation. And so Therefore, this California licensed foresters case that you have cited there at 30 Calap 4th 562, this case really suggests that if you want to get 1021.5 fees in your Business and Profession Code 17200 action, it really is going to be limited to cases where the plaintiff's motivation falls on the altruistic side of the line more than the personal side of the line. And if it's mixed motive even, fees can be denied or reduced. In such cases, the court reasoned, fee recoveries should be denied because the plaintiff's economic motivation alone, without the lure of recovering attorney's fees, is sufficient incentive for bringing suit. That brings us to the conclusion of this 17200 presentation, in Terrorem in California, and I hope it's been informative and educational to really see the real scope of Section 17200. In essence, it's the broadest mini FTC law in the nation. Because it borrows FTC law for purposes of the unlawful prong, it makes actionable a whole range of conduct that otherwise would only be touched by the federal government. And now it can be touched by not only the state attorney general of California in a public attorney general action, but also by private litigants in individual cases or wrapped up as class action cases. And so for this reason, 17200 has been called the broadest mini FTC law in the nation. The second critical point in conclusion to keep in mind is that it reaches conduct outside of California when business direct their conduct into California. And I think it's so critical in the modern internet era to keep in mind that when your clients may be transacting business in a different state, and they may even be selling primarily in that state, but they have a website that advertises nationally, and they may ship products across state lines into California on occasion. They may be subjecting themselves to personal jurisdiction in California, and when you run the minimum contacts analysis and they get hauled into California, you now suddenly have businesses that never thought for a second they were going to be regulated by California as a legal regime, now being subjected to California's legal regime and this very broad 17200 law on liability, at least, this incredibly broad law with very, very broad remedial, injunctive relief remedial provisions too. The other key point is that it's not just competitor on competitor. This is a decidedly consumer-oriented protection law now that really facilitates and allows broad consumer protection litigation to protect underlying consumers. And so it's not just a sort of appendage to antitrust laws to deal with competitor on competitor cases. There are myriad in Terrorem points that we've talked about today that you want to keep in mind and be aware of. I'd go back to those slides and look at them because they're great practice pointers. And keep always in mind that there are these broad equitable remedies, but there's a very limited restitution definition which helps out at least on the damages side. So, as of 2018, California currently has the largest Democratic majority in its state legislative body in over a century. So stay tuned for potential amendments to 17200 that may broaden liability even more. Thank you for watching today's presentation.